Well, guys, now we are going to discuss something new and something more about Supreme Court. Well, there is so much of information about the Supreme Court, its composition, and so on, so on, so on, so on. So, what's something new? Now we are going to discuss about Supreme Court. In this chapter, we are going to discuss about Supreme Court, how the Supreme Court was established, and before the establishment of the present Supreme Court, what was the story of judicial system in India, and after the establishment of Supreme Court, what were some of the issues like the composition of Supreme Court and the appointment of judges, and the most important thing, what was the main issue regarding the appointment of Supreme Court judges. So these are the things we'll be discussing about Supreme Court in this particular video. So whenever you need justice, then please go and knock the doors of Supreme Court here. And before you knock the doors of Supreme Court, just knock the doors of your brain and open the doors of your brain so as to fill it with the general studies knowledge and help yourself in the prelims, mains, and so on, so on, so on examinations, and finally knock the door of success. So let's begin the class. What is the need of Supreme Court in India? Why there is a need of Supreme Court in India? Why do we need Supreme Court? Why? Because India is a federal system, and India is a federal system, so there may be conflicts between states. So in between states there may be conflicts. So as to solve all those problems between states, we need a Supreme Court, that is a judicial body. And when there is a problem or when there is a conflict between this union government and the state government, or the union government and the state governments, then we need a judicial body so as to look after the issues, look after the situation, and set all the things. So that's why we need Supreme Court. And at the same time, our constitution have guaranteed fundamental rights to our citizens. So when the government is encroaching upon the fundamental rights of the people, then there is a need to protect the fundamental rights of the people. So as to protect the fundamental rights that are guaranteed to the citizens, we need a judicial framework, we need a judicial authority, and that is Supreme Court of India. So that's why we need Supreme Court of India. Hence, an integrated and independent judicial system was set up. Okay, an integrated independent judicial system was set up by the Constituent Assembly so as to uphold and protect our constitution. So remember, our judiciary is integrated and independent judicial system. Remember this point. Okay, so this is how we have established a Supreme Court, and these are the reasons why we need a Supreme Court. Okay, so in part 5 of our constitution, in chapter 4, from article 124 to 147, we can know about so many things. And what are those things? How the Supreme Court was created, and what is the jurisdiction of Supreme Court, and what are the powers of Supreme Court, and what are the functions of Supreme Court. All these issues are discussed from article 124 to 147 in chapter 4 of part 5 of our constitution. The next, how we have established the Supreme Court. We need to know the story of birth of Supreme Court in India. According to the Regulating Act of 1773, we have established first Supreme Court in Calcutta in the year 1774, that too in Fort William. Okay, so in Fort William, Calcutta in 1774, according to the 1773 Regulating Act, we have established our first Supreme Court. And in that Supreme Court, there was a Chief Justice and along with 3 judges. So the first Chief Justice of the Supreme Court of India in 1774 were Lord Elijah Impey. So this person, you need to remember the name of this person, Lord Elijah Impey. Name is a little bit difficult, but no, never mind, you have to remember this one. Lord Elijah Impey is the first Chief Justice. So many times, in so many examinations, this question is asked, who is the first Chief Justice of India? Remember, there is a first Chief Justice of India prior to our independence. There is another Chief Justice of India after independence. So we'll be discussing about that thing. The judgments of this court can be appealed at Britain's Privy Council. So we need to understand and we need to remember a fact that whatever the cases or whatever the trials were going on in the Supreme Court that was established in 1774, those particular judgments or those particular trials can be challenged at Britain's Privy Council. What is Privy Council? Privy Council is nothing but it is the upper house of Britain's Parliament. So it is also called House of Lords. Okay, so the House of Lords of Britain, that is the upper house of Britain, is called the Privy Council. So whenever a judgment is given by the Supreme Court of India, the Supreme Court of the British India, that particular judgment can be challenged in Privy Council. Okay, it can be appealed in Privy Council. Then, as per the Government of India Act 1935, a federal court was established in New Delhi, that too in the year 1937. So you need to remember that in 1935, as per the Government of India Act 1935, a federal court was set up. Okay, so earlier we had a Supreme Court that was running especially on the lines of the British rule, but later when the situations were changing in the year 1935, as per the Government of India Act 1935, a federal court was established in Delhi in 1937. So that's how the Indians gone a step ahead in establishing a judicial system, a perfect judicial system. Then the first Chief Justice of this federal court was Sir Marine Goel. Not so important, but you need to remember, Sir Marine Goel is the first Chief Justice of federal court. Okay, federal court. I am talking about the federal court. The next one, after the adoption of our constitution on 28 January 1950, Supreme Court started functioning. So what actually happened is that in 1935 we had a federal Supreme Court. So when we had adopted a constitution, when we have framed a special constitution for ourselves, so from on 29th January onwards, 1950 onwards, a new Supreme Court has been started functioning at the union level, and that Supreme Court is existing till now. So the first Chief Justice of independent India, okay, the first Chief Justice of independent India is H.J. Kanya, okay, H.J. Kanya, okay, H.J. Kanya is the first Chief Justice of independent India. You need to remember this name. Then our constitution adopted some kind of concepts and some kind of systems from other countries so as to strengthen our judicial system. So what are those things? Basically, India has adopted the concept of integrated judicial system and the concept of equality before law from Britain Constitution. So, Indian Constitution has adopted from Britain Constitution two things. What are those two things? Integrated judicial system and equality before law. You need to remember these things. Then again we have adopted judicial review and independent judiciary from USA. So judicial review and independent judiciary we have brought or we have adopted from the Constitution of United States of America. Okay, so this is all the basic things we need to understand, that how the Supreme Court was established in India, how a particular judicial system was established in India. Okay, the next, we have discussed how the Supreme Court was established, but now we have to discuss what is the composition of Supreme Court. At present in Supreme Court there are 31 judges. 31 judges. Among these 31 judges only there will be one Chief Justice. That means 30 judges along with one Chief Justice, that is 31 judges. That is the present composition of Supreme Court. Earlier there were only 26 judges. Okay, earlier there were only 26 judges, but according to the Supreme Court Amendment Act 2008, in February 2009, the number of judges and Chief Justice were increased from 26 to 31. Okay. Then in the first Supreme Court, there were only one Chief Justice and 7 judges. So you can understand what were the condition there. At the time, the population was very less in our country, and at that time there were not huge cases lying pending on the table of Supreme Court. So there was not much work, or there was not the work pressure for Supreme Court then. So that's why there was only one Chief Justice and 7 judges at that time. Later, as per the situations, as per the changing circumstances, we have increased the strength of Supreme Court, that is the composition. We have increased the Chief Justice and the judges from 26 to 31 as per Supreme Court Amendment Act 2008. Okay, the next one. According to Article 124 Clause A, you need to remember this article. According to Article 124 Clause 1, the number of judges can be increased by the Parliament. That means it is the Parliament which can decide that how many judges should be there in a particular court, whether it is High Court or Supreme Court. So the number of judges that should be there in Supreme Court or High Court, it will be decided by the Parliament only, and whether to increase or decrease, it will be in the hands of Parliament only. You need to remember this point. Then the minimum number of judges, how many what is the minimum number of judges should be there in our Supreme Court or High Court? The thing is that nowhere in our constitution, there is no provision in our constitution which is telling us that there should be such and such minimum number of judges in our Supreme Court. There is no provision at all. So that's why there is no mandatory rule that there should be minimum number of judges we should have in Supreme Court. So there is nothing like that. Okay. Then at present the Chief Justice of India is Mr. Jagdish Keher. He is the 44th Chief Justice of India. Remember this number. In state PSC examinations it is asked. The present Chief Justice of India, that is Jagdish Keher, he is the 44th Chief Justice of India. Okay. So Mr. Jagdish Keher, he is the present Chief Justice of India. Have a look at him. He is Mr. Jagdish Keher. He is the present CJI, that is Chief Justice of India. He is the 44th. He is 44th Chief Justice of India. Remember this point. Okay. Basically, what is the importance of this person is that Jagdish Keher, he is the 44th Chief Justice of India. He was the Chief Justice of the Constitutional Bench, which squashed the NJAC, that is National Judicial Appointment Committee. So the National Judicial Appointments Committee was squashed by a constitutional bench, and the chief of that constitutional bench was Mr. Jagdish Keher, who is the present Chief Justice of India. And as a judge, he quashed the president's rule in Arunachal Pradesh also. It was a burning topic then. So that's why he got all the attention from the people. That person is Jagdish Keher. So these were some of the important current affairs related information regarding the Chief Justice of India. I have included that particular thing in this one also. Then let's move to the next one. The next topic we are going to discuss is about the appointments of Supreme Court judges. As we have discussed the composition of Supreme Court, now we are going to discuss about the appointment of Supreme Court judges. So about the Supreme Court judges appointment, there is one article, Article 124 Clause 2. This particular article is telling us about the appointment of Supreme Court judges. So as per this article, what this particular article is saying is that President of India appoints judges. So it is clear that President of India is the person who is appointing the judges either for Supreme Court or for High Court. Okay. So President, if feels necessary, he can consult the Supreme Court Chief Justice and High Court Chief Justice in the matter of appointing the judges. That means when the president is not having a clear-cut idea that who is the most eligible person to become the next Chief Justice of either Supreme Court or High Court, then he may take the advice of the present Chief Justice of Supreme Court of India. As per the article, there is one article according to which he can consult the Chief Justice advice. Okay. So President appoints other judges after consulting the Chief Justice of Supreme Court and judges of Supreme Court and High Court also. Other judges means the ad hoc judges are there. So as to appoint those ad hoc judges, the President may seek the advice of he has to seek the advice of, he has to consult the Chief Justice of Supreme Court, the judges of Supreme Court and the High Court too. So he need to consult. So the president must consult the Chief Justice to so as to appoint all the judges. It is clear in this Article 124 clause 2. So why I am stressing on this particular word, he must consult? Basically, in this provision, this particular word is very important. Why? Because later this particular word became a controversy. Here, the president must consult the Chief Justice so as to appoint all judges. It is quite clear in this particular sentence. But later on, regarding this particular word, that is, the president must consult, this word became very much controversy. What is the controversy? Basically, what happened is that whether it is mandatory that the president should consult the Chief Justice in regarding the appointment of judges. That was the first question. The second question was that even if the president consults the Chief Justice, then it is mandatory for the president to obey, or he has to accept and implement the advice given by the Chief Justice. Is it necessary? Is it mandatory? So such kind of questions were there. So on the basis of those questions, there arises some controversies. We need to discuss about those controversies. Then only we can understand how the judges are being employed and are being appointed. So let's move on to that issue. So the controversy over consultancy. Now we are going to discuss about this thing. Okay. So the Supreme Court interpreted the word consultation in many ways. Basically, now we are going to discuss about three main cases in which we will be discussing about different issues that took place in each case and how the Supreme Court has interpreted the word consultation. The consultation means the consultation of president. He is consulting the Supreme Court Chief Justice so as to appoint other judges. So here the entire matter is related to the word consultation, that too in the matter of appointment of judges. So let's discuss about the first instance, that is the case, the popular case, that is the SP Gupta versus Union of India 1982 case. This case is also called very much popular as judges of the first judges case. So it is called the first judges case, that is SP Gupta versus Union of India 1982 case. In this particular case, Supreme Court gave the judgment that consultation doesn't mean acceptance. It only means opinion sharing. That means if president is asking for aid and advice to Supreme Court Chief Justice, it doesn't mean that he should accept the aid and advice given by the Chief Justice of India. It is up to president whether to follow the advice, whether to implement the advice or not. So that's what the judgment was given in the first judge's case. Okay. Then again in the next case, that is the second judge's case, here the entire scene reversed. What happened in this particular case? Second judge's case is the Supreme Court Advocates on Record Association versus Union of India 1993 case. This is popularly called the second judge's case. What happened in this is that Supreme Court has reversed its previous verdict. It said that consultation means acceptance here. Earlier, Supreme Court said that mere consultation doesn't mean acceptance. But now Supreme Court said that consultation means acceptance. Now the entire scene has reversed. So in the matter of appointing judges, the advice given by the Chief Justice must be implemented by the President as per the verdict given by the Supreme Court, which is saying consultation means acceptance. That means if President of India is consulting the Chief Justice, then whatever the advice is given by the Chief Justice, it has to be obeyed, it has to be accepted by the President. Okay, it has to be implemented. That's what the second judge's case is saying. In this matter, the Chief Justice should consult the senior most judges of Supreme Court and give his advice to the President. So basically what it is clear in this particular scene is that the Chief Justice should consult the senior most judges of the Supreme Court and then he should give his advice to the President. Okay, then the President has to accept the advice given by the Chief Justice. So that's what clear in second judge's case. Then later what happened in third judge's case 1998 is that we need to take a look at this particular case. in first case it is said that mere taking advice that sorry, taking advice doesn't mean acceptance. Then in second judge's case it was made clear that taking advice or asking for advice, then if a chief justice gives advice, that means acceptance. So here consulting means acceptance, the advice has to be accepted. But later in third judge's case something new happened. What happened in third judge's case? Basically the third judge's case held in 1998. Basically under article 143, that is president consulting supreme court chief justice for any matter. That means whenever the president wants the help of the law to know whether what to do and how to do on the basis of justice and judicial lines, then the president of India can consult the supreme court chief justice so as to take advice on any serious issue under article 143. So under the third judge's case, the Supreme Court gave such a verdict which has expanded the scope of the article 143. So in this particular case, the Supreme Court has expanded the scope of president consulting the Chief Justice of India. So what actually happened is, appointment of judges of Supreme Court. For the appointment of judges of Supreme Court, the Chief Justice of Supreme Court must consult the collegium, that is the four senior most judges. What is collegium? Collegium is nothing but it is a group of four senior most judges. Okay, so whenever there is the issue of appointing judges, then for the appointment of judges, the Supreme Court Chief Justice will consult these four senior most judges. And these four senior most judges is called collegium. That means the Chief Justice of India has to consult the collegium. And in this collegium, if out of these four members, if any two members raise objection regarding the advice that has to be given by the Chief Justice, then the Chief Justice must not recommend such an advice to the government. That means if the Chief Justice have taken one decision that he is going to advise in such and such way, then among these four members, if two of the members feel that the advice given by the Chief Justice is not perfect, that particular advice is not good, then Chief Justice must not give that kind of advice to the President. In case if Chief Justice does not follow the procedure of consultation, that means even these out of these four members, two members are objecting the advice given by the Chief Justice. Even in that case, Chief Justice advises the President, then that means he is not following the procedure of consultation. Then it is not necessary for the government to follow the Chief Justice advice. Okay, so that is the verdict given in third judge's case 1998. So this is all happened in 1998 third judge's case. So in this lesson we have discussed about Supreme Court, how it was established, what is the need of Supreme Court, and after establishment of Supreme Court, what is the composition of Supreme Court. Then we have discussed about the appointment of judges. Something more is there, we'll be discussing about that thing in the next video. And be happy and be positive, always keep smiling, and never ever just undermine yourself. You are the best, you can do wonders, you are having all the strengths. Remember, if you think you can, you win. All the best and thank you.